is the one that I chose. Okay, so let's go on to the next page, which is my declaration. Okay, you're going to do lots of declarations if you work for an attorney, particularly family law. Okay, now the most important thing you need to know about motions is they're signed under penalty of perjury. So the person signing them has to make sure that the stuff is accurate, so it doesn't come to bite you later. Okay, you don't want to perjure yourself in front of the court. Okay, every motion starts out I, whoever it is, declare, colon. Okay, and then the paragraphs are numbered. Why are the paragraphs numbered? Because I reference each part of my declaration in the motion itself. So the judge can move from the points and authorities directly to my declaration and see exactly what evidence I presented to support that particular part of my points and authorities. Okay, always starts out something like, I'm duly admitted to practice law in the state of California and I represent the plaintiffs. Okay, the facts, this is going to be in every first paragraph of every declaration you ever write. The facts stated are based upon my personal knowledge, and if called to testify, I could and would competently testify thereto. The facts in your declaration need to be based on personal knowledge. Well, what does that mean? I didn't hear it from somebody else. I know this stuff, and I personally experienced it. So I can't go in and say, well, so-and-so told me this. Okay, I can't go in and say that. I have to have the person that actually has that knowledge make a declaration themselves. Okay, so be careful about that. Okay, here we go. Paragraph 2, I served an inspection for documents. Okay, a copy of that inspection, request for inspection of documents is attached as Exhibit A to my declaration. Okay, so the original of this would actually have an exhibit tabs at the bottom, and Exhibit A would be my actual motion request for production of documents, okay, and the interrogatories. Okay, now when no responses were forthcoming, okay, actually I probably should have put in also here, this must be a draft. Oh no, it's in there, never mind. Never mind. Okay, let's go on to paragraph 3. When no responses were forthcoming, I wrote defense counsel. And normally we go ahead and before we run into court and file a motion to compel, the judge is going to want to see that I tried to work it out with the other side. Okay, so, and this happens all the time. If you run into court right away and file a motion, well, if they serve the responses before the motion is heard, then, you know, I've just wasted a bunch of time drafting a motion. Okay, so when no responses were forthcoming, I wrote to the defendant's counsel. He requested an extension of time, which I granted. This lets the judge know I've been reasonable, okay, because that's important when I ask for my sanctions, that I've been reasonable, okay. So I granted him an extension of time to respond, okay. Despite the extension, no responses, okay. I'm requesting sanctions of $900. My hourly rate of $125 plus 6 hours. Okay, that's how I got 900. Okay. Now, the end of a motion, a declaration will always end this way. I declare under penalty of perjury on the laws of the state of California, or if you're in federal court, on the laws of the United States, that the foregoing is true and correct. So I'm swearing under penalty of perjury. And then we have the date that I executed this declaration and my signature. Okay, that's basically it for a simple motion under California law. Okay, the other thing you need to know, and you probably need to draft when you do this, even though I didn't include it, is an order. Okay, the reason is the judge is not going to write the order for me. I have to write it. So I will have, when I go to court on the hearing of this motion, I will have a proposed order for the judge to sign. Okay, so the proposed order will say the motion came for hearing, good cause appearing, plaintiff's motion is granted, the sanctions are granted, the judge signs that motion. He either signs it, gives it back to me right there, or takes it and signs it and mails it back to me, and then I have to serve that order on the other side. Okay, those are more civil procedure issues, but remember, when you draft a motion, you have to draft a sample or a proposed order for the judge to sign, because he's not going to write it up for you. Okay, that's the end of this lecture. On Monday or Tuesday, I will have your assignment up. I'll also have some other documents for you to look at, like points and authorities. Don't get too freaked out about the motion that you need to draft. I'm more concerned about you making the effort to try to do it than the actual product itself. Okay, you guys have a great day.